So we've got a brand new lawsuit filed against the National Firearms Act, and it's based on the same $0 tax change that we've been talking about and tracking in some other cases. But here's what makes this new challenge so different. This case is not in Texas, it's not under the Fifth Circuit's jurisdiction, it has now been filed in the Eastern District of Kentucky, which means that the strategy now to dismantle the NFA after this Congress change of the $0 tax, reducing from $200 to $0, is expanding in fact to new jurisdictions. This is no longer a single case theory, this is becoming a coordinated multi-court attack on the NFA's constitutional foundation. So let's break down what is happening in this new challenge. Now, before we jump into this video, I want to mention that if you want to support the channel, one of the best ways to do that is simply to subscribe. About 60% of all viewers are actually not subscribed, so if you want to support the channel, subscribing is simply a great way to do that. I also want to thank the sponsor of this video, which is TacPack. TacPack is a subscription-based box that delivers tactical and EDC gear to your front door every single month. And right now, TacPack is doing something special. The next TacPack Plus box features AR gear, range gear, and other amazing pieces of training gear that you would be interested in potentially. And the March TacPack Plus box is going to be worth over $282. And if you sign up using my code ARMED, you can get a free $60 tactical gift along with that subscription. So if you've been interested in TacPack for a while, this is the month to jump in, especially if you want to get that additional free gift and additional value. So remember, if you sign up, use code ARMED to get that free additional tactical gift. So as you know, Congress recently passed the One Big Beautiful Bill. In that, they also had the elimination of the NFA's $200 tax, the reduction of the $200 making and transfer tax for suppressors, short-barreled rifles, short-barreled shotguns, and AOWs. And this plays off what the Supreme Court said also about the NFA, where potentially the NFA could be constitutional because it was an exercise of Congress's power to lay and collect taxes. But now for most NFA items, because of the One Big Beautiful Bill, the tax is zero. The registration regime, although there is a $0 tax, still remains. The criminal penalties still remain, but the revenue purpose, which was in fact the constitutional hook, is now gone. That's the theory that is now currently driving all of these new lawsuits. And because of this, a new lawsuit against the NFA has been launched in a new jurisdiction. Now, this new lawsuit has been filed to dismantle the NFA, and the complaint was filed with support of Second Amendment Foundation and FPC, I believe. In this, you had some individual gun owners in the state of Kentucky, some Kentucky-based firearms dealers, I believe Buckeye Farms Association, the Center for Human Liberty, and then also I believe there was the American Suppressor Association and that foundation that was attached to this lawsuit as well. And again, this was filed against the ATF and the DOJ for their current enforcement of the NFA. This case is not simply just about criminal defense and that type of situation. This is a pre-enforcement, declaratory, and injunctive challenge against the NFA. They're asking for the court to declare that the NFA is unconstitutional as it applies to the now untaxed items because of the One Big Beautiful Bill, and they're asking for the court here to enjoin the enforcement of the NFA. Now, in this new lawsuit, the complaint makes a very direct argument. They argue that the NFA was constitutional only because it functioned as a tax. Now that Congress has eliminated the tax for most covered items, the regulatory scheme no longer rests on Congress's enumerated taxing powers and authority. And unlike the Gun Control Act, the NFA contains no interstate commerce jurisdictional hook that is essentially at the core of its provisions. And that's very critical because they're arguing that there is no longer a valid constitutional basis to have the NFA still operate as it is. The plaintiffs argue that you can't convert a tax statute into a permanent regulatory regime once the tax disappears, and if there is no tax, there is no constitutional basis for the NFA, and it must be done away with. But this case doesn't stop with just the taxing clause in those arguments. It also makes a full Bruin Second Amendment argument based on how the NFA needs to be done away with. The complaint argues that suppressors are arms protected by the Second Amendment, that short-barreled rifles are also protected arms, and that they are in common use for lawful purposes and they're not dangerous and unusual items. The government itself, they point out, has conceded that suppressors are protected arms in another piece of litigation, which was the Peterson case in the Fifth Circuit. So the plaintiffs argued there is no constitutional tradition supporting the NFA's comprehensive registration regime for these types of protected arms. And because these items are now untaxed, the government cannot rely on the taxing power justification anymore in these cases. Now, like I mentioned, this case is filed in the Eastern District of Kentucky, which is within the Sixth Circuit's jurisdiction. Now, that matters strategically because the Sixth Circuit has older precedent upholding the NFA only under the Commerce Clause. But that precedent kind of predates Bruin and predates the $0 tax change that has now happened with the One Big Beautiful Bill. So this lawsuit forces a new appellate court to confront the same constitutional question that is now also being litigated in Texas and also in front of the Fifth Circuit. If also, one of the critical things with this case, if there is a circuit split, that dramatically increases the likelihood that the Supreme Court will need to get involved and review this issue. So here's the bigger picture with this case. You have the Jensen and Silencer Shop cases that are out of Texas that are currently being litigated in district courts in Texas, and those are under the Fifth Circuit's jurisdiction. You also have the Peterson Suppressor case that was also in the Fifth Circuit and is likely also now heading to the United States Supreme Court. Now also on top of those, you have this new case that was filed in Kentucky in a federal district court, and that is under the Sixth Circuit's jurisdiction. This makes the strategy very clear when it comes to these cases. Attack the NFA from multiple angles. The taxing clause collapses after the $0 tax change. The Second Amendment common use analysis is being used because of Bruin. They're arguing that there are Commerce Clause limits. And then also there are facial and as-applied challenges that are being launched in multiple jurisdictions. Instead of relying on one court, plaintiffs are creating multiple vehicles and multiple cases to get this issue back in front of the Supreme Court. Because if one circuit court agrees that the NFA's foundation collapsed when the tax disappeared, the entire structure is destabilized and there is a circuit split on this issue, which the Supreme Court will have to address. The plaintiffs in this case want a declaration that the NFA's requirements for untaxed firearms exceeds Congress's enumerated powers. They want a declaration that suppressors, short-barreled rifles, and short-barreled shotguns and AOW regulations violate the Second Amendment. And they want a permanent injunction against the enforcement by the ATF and other agencies against these items based on the NFA. So this is a sweeping request that is being made in this case. They're not asking for some minor tweaks. They're asking for the court to dismantle the NFA's application to suppressors and SBRs entirely because of the $0 tax. So this is no longer just theoretical. Congress changed the tax, and the plaintiffs here and the litigants here in these cases are now testing whether the change kind of collapses the constitutional justification for the entire NFA scheme. And this is a new case, and a new case showing that the challenge is currently spreading and is moving into different courts, different circuit courts, and they're all using the same $0 tax theory. And again, if one circuit splits from another, the Supreme Court will have to step in. So this is a major development in the fight over the NFA. A brand new lawsuit was filed in a district court in Kentucky. It deals with the same $0 tax theory because of the One Big Beautiful Bill. It also has a broader Second Amendment attack that's being brought in this lawsuit. And then also because of this, you're going to get new circuit courts involved in this NFA question. And so right now you have a lot of pressure building against the NFA, a lot of cases that are being launched trying to use the $0 tax change to essentially dismantle and block the NFA going forward. So that's what's currently happening in this new lawsuit that was launched against the NFA, against the suppressor and SBR restrictions and all these other item restrictions. As it develops more, as we get more information, as there's critical movement in this case, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this type of two-way content, and so it shares it to more people. But as always, thank you so much for all of your support, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.